A new lawsuit from a California family claims that they were told their loved one had left the hospital against medical advice more than a year ago, when in fact, she had died and was found decomposing in a hospital storage facility. We're digging into who could be held responsible with personal injury attorney Alea Roberts. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. This is a wild and very unfortunate story. It's about 31-year-old Jessie Marie Peterson. Now, she was diagnosed with type 1 diabetes when she was just 10, so the occasional hospital visit wasn't really out of the norm for her. You know what is out of the norm? What you're about to hear about. Because when she went to Mercy San Juan Medical Center in Carmichael, California, this is outside of Sacramento, in April of 2023, Jessie calls her mom, Ginger Congi, to let her know that she was there. But then a few days later, after she was admitted, when Ginger called and asked to be transferred to Jessie's room, hospital staff allegedly said there weren't any patients there with that name. And staff allegedly later told Ginger that her daughter had left the hospital AMA, that means against medical advice. So when Jessie's family members couldn't get in touch with her, they reported her as a missing person to the Sacramento County Sheriff's Office. Search parties were organized, missing posters were put up. There were no signs of Jessie. Well, in new legal filings, Jessie's family says, do you know why they couldn't find her? Because Jessie was in a cold storage facility with the hospital's morgue. She had died within hours of speaking with her mother on the phone that first day. That was April 8th, 2023. And when does her mom say that she found this out? April 15th, 2024, more than a year after she died. Attorneys on behalf of Jessie's mother and sisters have filed a $25 million lawsuit against Mercy San Juan Medical Center, which is run by Dignity Health. I want to talk about these very disturbing allegations with personal injury attorney Alea Roberts. Alea, good to see you. Your Sidebar debut. Yeah, great to see you. You handle these kinds of cases, right? But have you ever seen anything like this?
Never in my life. And I went on both sides, from personal injury side from the plaintiff side and personal injury from the defense side. So essentially defending some of these hospitals. And I know that the hospital is going to allege that this AMA against medical advice means that we're not liable. The problem is, of course, as you know, with negligence, you have duty, you have breach, causation, and damages. The hospital breached this duty to Ms. Peterson when they didn't inform the family for over a year that she wasn't there.
We're going to get into these different causes of action. What do you mean that they're going to say against medical advice they're not liable? If they're the ones who say she was discharged from the hospital when she wasn't, whether it was gross incompetence, a mistake, or they were lying about it, what do you mean? How can they not be liable?
Well, there has to be some sort of defense, right, from the hospital standpoint.
I don't know what it is.
There has to be a defense. So they're going to say, oh, well, she was discharged. And I bet my bottom dollar that there's somewhere in the medical records, they're going to say that the victim left against medical advice, and that's their defense. Now, how do you explain her ending still up on her property a year later? That's what we have to watch out.
Wait, I'm confused. If she died in the hospital, she never was discharged.
But right, she was not discharged, but that's the hospital's defense. The hospital is saying she left against medical advice. There's going to be somewhere in the record that we told her not to leave and she left. The problem is they can't actually sustain that defense.
They can't prove she left.
They can't, but they're going to. It's not about what you can prove or argue.
Well, no. If during the course of litigation, you would get the surveillance footage, right? Did they ever see her leave the hospital?
Right.
She never left the hospital. That doesn't work. Here's the thing. We got our hands on this lawsuit. It was filed on August 7th, and we're going to break it down. So first, the causes of action that are listed in the complaint. We're going to get into it a little bit later, but we have negligent handling of a corpse, negligent infliction of emotional distress, and violation of California Health and Safety Code, Section 7100. Now, according to the complaint, as I mentioned, it goes into that Jessie suffered a diabetic episode on April 6th, 2023. She was admitted to the Mercy San Juan Medical Center. Her medical records indicated a discharge date of April 8th. And as I said, the family was told she was discharged against medical advice. But then the complaint says, quote, Jessie's certificate of death, not completed until nearly a year after her passing, states that she died from cardiopulmonary arrest at age 31. Because Jessie's death was not reported to family for a year after her death, an autopsy to determine whether medical malpractice played any role in her death was rendered impossible. And later on in the complaint, the attorneys put it pretty bluntly. On April 9th, 2023, Mercy San Juan Hospital transferred Jessie's body to a cold storage facility. Jessie was placed on shelf number Red 22A and forgotten. And that is also accompanied by a photo of a transfer receipt dated April 9th and a signature. Again, Alea, you have the paperwork here. I don't know how the hospital defends itself.
I don't know why the hospital has not settled this case. This is one of those cases that you don't want to get out into the news, right? You don't want them to file a lawsuit. You want to keep it quiet because then this opens the door to not just what they're demanding. If this goes to the jury, they could get even more than the $25 million that they're demanding. Like I said earlier, they have to have some sort of defense, right? So their defense is going to be, we were taking care of her, she left against our advice, the medical records say she left against our advice. Maybe there was a individual who might have been an independent contractor, because sometimes you have people who are hired by the hospital, and even though they don't work directly for the hospital, they might work for a third-party contractor that is in contract with the hospital. So it's like, oh, this person who we don't employ or we're not responsible for, this third-party company who was handling this corpse, it's their fault.
What about the fact that the certificate of death wasn't completed for a year? Would it have been worse if it was completed immediately and the family wasn't notified? If it was completed for a year, could the hospital say, you know, we didn't have all the answers? You know, some people were saying one thing, some people were saying another thing. Does that help them at all?
I think it would help them as far as that California statute, the statutory negligence that they were arguing earlier, right? The mishandling of a corpse. To the extent that we completed the certificate of death as the hospital, we being the hospital, we completed the certificate of death. We thought that whoever was responsible, not us as the doctors or us as the individuals performing the autopsy, someone else was responsible for calling you and telling you that the victim, in this case, Ms. Peterson, was deceased, and informing the family.
A massive lawsuit like this, how could I not talk about Morgan & Morgan, specialists in the personal injury field, America's largest injury law firm, our sponsors here on Sidebar. They have over 1,000 attorneys. They provide their clients a dedicated team of investigators and paralegals. The whole process can be done straight from your smartphone. There's no upfront fee. You only pay them if you win. They have a track record of verdicts and settlements in the multi-millions. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar. Just back to that medical malpractice, because of the condition that her body was in, the family can't sue because they don't, I mean, they could, right? They could sue for medical malpractice saying that the hospital caused Jessie's death, right? That's what I would imagine they would try to be saying, but they can't definitively say that because of the condition of the body, right?
And the hospital is going to say, well, the diabetes caused her death and not anything that we did on our behalf because she had this pre-existing condition. A hospital, as for their defenses, they will always go to the pre-existing condition before they go to any type of negligence on their behalf.
But isn't there anything in the records when she died, what happened? Isn't there any way to check that?
There is, right? But if the hospital can go, a hospital can go back in and what's called add a notation to a medical record. So they can put a note saying that we discharged her on this day at this time and haven't heard anything else from her. And then when the family gets these records, or the attorneys for the family get these records, they're going to say, wait a minute, this is wrong. Now, they can ask questions about it at a deposition and further in trial, but that's unfortunately, when we were in the side of plaintiff's side, we'd say the medical records don't lie, right? But every once in a while, there's something in there that says, this isn't correct, this is wrong, something is wrong about this. And as the hospital, especially whoever was responsible for making sure that the family was informed, had access to that record. And to cover their own self, they might add a notation saying, she was discharged, Ms. Peterson was discharged against medical advice.
So Dignity Health, which I said is the owner of this, the operator of this hospital, they released a statement saying, we extend our deepest sympathies to the family during this difficult time. We're unable to comment on pending litigation. Not surprised by that response. But I want to go a little bit more into this. So nearly a year to the day after Ginger last spoke with Jessie, the family gets a call from the sheriff's office letting her know that Jessie was found deceased. And following the call, Angie, that's Jessie's sister, drove to the Sacramento County Coroner's Office. This is the allegations put forward in the complaint, where a staff member informed Angie that Jessie was not housed in their office. So he then directed Angie to call Mercy San Juan to ascertain Jessie's whereabouts. Angie apparently left a message with the Mercy San Juan's mortuary department inquiring about her sister. And the complaint says, quote, on April 15, 2024, Ginger called Decedent Affairs and spoke with an individual who answered immediately. When Ginger inquired about the circumstances surrounding her daughter's death, the responding woman asked for Ginger's number, stating that she will call her from a quieter place. Ginger never received that call, Ginger then contacted Mercy San Juan Security regarding any belongings the hospital may have had that belonged to Jessie. Security stated that there were none. And finally, that same day at 11:50 a.m., East Lawn Mortuary contacted Ginger Kanji, informing her that Jessie's body was found in one of Mercy San Juan's off-site storage facilities. So, Leah, it sounds like from this, like the hospital never told the family where Jessie was found, but maybe the funeral operation did. But it seems like it's still the responsibility of the hospital to know this.
For sure,
and to inform the family.
100% agree. The last known location for Ms. Peterson was at their hospital, right? So, and then her body was found at their hospital, to the negligent infliction of emotional distress claim that.
Well, can we go into this? Can we go into the different
sure.
claims? So I want to go through the different claims. Let's go over it together. First, we have negligent handling of a corpse. So by law, the hospital is required to adequately care for human remains. And the lawsuit states, quote, defendants breached that duty to plaintiffs by failing to properly care for Jessie's remains. Indeed, while in defendant's possession, Jessie was left decomposing for over a year. As a result, Jessie's body was so discolored that her tattoos could not be identified. Moreover, Jessie's fingerprints were not obtainable for any keepsake, and Jessie's family could not say goodbye or hold an open casket funeral. The mishandling also denied the family the option of an autopsy. Defendant's conduct caused damages and is so egregious to justify the imposition of punitive damages. So obviously, horrific thing to think about. And they mentioned the inability to perform the autopsy, which we talked about. But the punitive damages, I think, is key here too, right?
I agree. And it's really important because it's not just about punitive damages means that the conduct, like you said, is just so egregious and just so horrible that any type of money or any financial compensation that I would be awarded from this lawsuit isn't enough. I also need the hospital to be punished, right? Punitive damages. So this does not happen to another family, because in the event that they did not seek punitive damages, that gives hospitals across the country the freedom to do whatever they want to do in cases like this, right? Which means I can wait for a year before I call and let a family know that, their loved one died at our hospital.
And I think it's going to be really tough for them to say they handled the body properly when you see the condition of the body
Correct.
a year later. So then we have negligence. Defendants breached that duty when they failed to notify Jessie's family of her death for a year. Defendants had extensive contact with Jessie's mother, and she was also listed as her next of kin on hospital records. And you think about what happens if Jessie's family hadn't been so relentless. This feels like a strong claim,
Yes.
right?
Yes, I think that sometimes when people parties sue for negligent infliction of emotional distress, you have
Well, that's the next one.
Oh, excuse me.
So let's
regular
so we have
negligence.
direct negligence.
Direct negligence
is easy to.
Duty, breach, causation, damages. That's clear cut.
Negligent infliction of emotional distress. I find this one interesting.
Yes.
I'll tell you why. So it says, quote, defendants should reasonably have anticipated that their conduct would have resulted in emotional distress. Because they failed to notify Jessie's mother about her death, Jessie's family continued the search for Jessie for over a year while suffering emotional and mental anguish for Jessie during their search. Now, Alea, I will tell you, sometimes I am cautious about this claim. How do you prove it? Is it a little too broad? I cannot think in recent memory of a better claim than this, given this fact pattern. If I were to law school to think about a fact pattern, where does negligent infliction of emotional distress come from? If you're talking about the anguish of a family and trying to find their loved one and then to not find out a year later that they're dead and it was the hospital's result, this feels like the most straightforward claim of all.
I agree. And sometimes when you have negligent infliction of emotional distress, the individual who is claiming it has to be within the zone of danger, right? Not sometimes, all the time. They have to be within the zone of danger or a bystander, right? In this case, no one anywhere, no attorney is going to argue that the fact that I did not know where my loved one was for a year, that I had a search party for a year, that I'm contacting coroner's offices, I'm posting flyers, they said they did their own search. No one is going to argue this is not textbook negligent infliction of emotional distress. Sometimes if it's a case where there's you're not 100% sure, I know that sometimes plaintiffs' attorneys will suggest that maybe you should see a therapist, maybe you should talk to someone. And that sometimes supports that claim when you have a weak claim. I don't think that anyone would argue that this is a weak claim at all.
No, searching for your missing loved one, think about what that does to you, what that's like, and then you find out the actual truth. Again, I think that's a pretty strong one. And then we have this final cause of action, violation of the Health and Safety Code. Quote, California Health and Safety Code, Section 7100, states that the control of a deceased individual's remains vests in the surviving competent parent or parents of the decedent. Defendants violated the section above by retaining control over Jessie's remains for over a year and failing to relinquish control of Jessie's corpse to her family. Alea, talk to me about that one.
Well, there's what's called statutory negligence, right? So on top of all of your other negligence claims, if there is a statute that the defendant breached, in this case, the hospital breached this California statute, that is another form of negligence, right? Here we have a statute that clearly says what you're supposed to do when someone has passed away. How are you supposed to inform the family? How you're supposed to handle the body? All of those things. And when you breached a clear law, right? It's a California law, it's a code. That is, you breached a statute, and in which case you have statutory negligence, because by breaching the statute is another form of negligence, in addition to the basic form of negligence and negligent infliction of emotional distress.
Now, at the end of this complaint, they lay out the prayer for relief, what they're looking for. Quote, 1, awarding in excess of $5 million for plaintiff's actual and statutory damages. 2, awarding 5 times the jury's award of actual damages to punish defendants for the outrageous and inexcusable negligence and complete disregard for the dignity of Jessie and failure to respect the rights and needs of Jessie's family. That's what we call punitive damages. And 3, awarding reasonable attorney's fees, interest, and costs to the full extent permitted by law. You mentioned before $25 million. Seems like an appropriate given this, but also it could be more?
It could be more. I think that sometimes, to the extent that negotiations fail, right? Because I would argue that if this has already hit the media, if the lawsuit's already been filed, they've been notified for this lawsuit for a long time. There's been discussions amongst the lawyers for a while, right? They didn't just automatically go get get an attorney and go straight to filing a complaint, because you have negotiations before. Maybe
you send a letter, things like that.
Right, you send a letter, you reach out to counsel, you talk to them about, well, maybe we can settle this without going into litigation. But in this case, I think that not only was litigation necessary, but the punitive aspect, right? You want to make sure that this hospital knows what you did was wrong, right? And I'm going to hit you where it hurts, which is your pocket, right? Yeah. And I'm going to make sure that this does not happen to anyone else and any other family. Now, to the extent that this case goes to trial, a jury might say, this is so egregious, this is so horrible, whatever they're asking for, I'm going to give them more than that. And then you have to go to the appellate process and see what's sustainable as an actual award, but that can happen. And we've seen that happen in cases across the country.
Yeah,
exactly,
yeah.
Right.
But walk me through the idea of settling, right? What are the advantages and disadvantages for the hospital to settle? And if they settle, what would be an amount that they might settle on?
Well, let's see. If the demand is $25 million, and then they're asking for an additional 5 times that. I think sometimes plaintiffs' counsel makes a demand that is very, very high, and there's a what I'm asking for versus what I'll take, right? So from the $5 million and the $25 million, they're asking for 25. Maybe they take 15. Right? Maybe that's that one claim that they'll take. They're asking for $5 million for the actual suffering. Maybe they take 3. But I think if they settle the case, I don't think that the hospital would accept punitive damages. And I think that's the key here. And to the extent that that's driving this lawsuit, right, I want to set a standard for the hospitals to make sure that no one does this in the future. That's where I think we'll get hairy. I don't think they would settle on a punitive damages claim.
Well, because then you have the time and expense of going through litigation, and that's why you have some of these discussions. But with that in mind, it's something that you mentioned before about not happening to other people, because in the complaint, it seems to reference that this isn't the first time that something like this has happened, because it says, quote, on information and belief, this is not the first time that Mercy San Juan Hospital has mishandled a decedent. USA Today also reported that the family's attorney, Mark Greenberg, said other people have called him to say their loved ones have faced similar fates at Dignity Health Hospital. So the question I ask you now is this going to be a bigger lawsuit? Are you going to have more plaintiffs join it? Which, if the concern was the time, the cost of litigation, it might now be easier if you have more people suing, or are we not going to see that, a big lawsuit?
I don't know, right? So there's one issue of statute of limitations, right? I believe I'm not sure about California law specifically, but generally you have about 2 years to file a medical malpractice claim, period, right? So after the statute has told, you might not be able to file a lawsuit. However, if I, as the attorney for the family, start asking questions at a deposition and the hospital says, no, this has never happened before, and we know that it has happened before, now I open the door to do what's called prior bad acts. I can know that the hospital has previously engaged in this type of thing, and even though I can't actually sue them, I can show that this is not the first time that it's happened.
The last question I have for you is the fact that, yes, Dignity Health released that statement, can't comment, I understand, but the fact that they haven't apologized to the family, is that because if they apologize, It's an admission that they did something wrong.
Correct.
But it doesn't look right.
No. But I mean, we don't care about what it looks like. If I'm being sued for $25 million, I want to make sure that I do exactly what my attorney says, right?
Yeah.
And if attorney says don't apologize, don't apologize.
Alea Roberts, thank you so much for coming on. It was a pleasure.
Thank you, Jesse.
Thank
Always
you.
fun.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.